that be a motion?
Yes, Your Honor. This is the Commonwealth's motion under 58A. What the parties are proposing is a stipulation under 58A. And then the Commonwealth and the defense have agreed to a series of conditions of release under 58A. The first 12 of those conditions are by agreement. The 13th condition is contested, and the parties are going to argue that condition for your honor. With respect to the record, the parties are requesting the court not to mention the name of any medical facility or doctor or the name of any family member that might be mentioned in that motion, just in open court. Is that right?
The privacy and the sake of the family members and the institutions, I think it's important that that information stay between the court and the parties, and we're going to ask that document, if adopted by the court, be impounded, Judge.
So there will be no mention of any medical provider or anything.
Yes, Your Honor. Thank you. Is the court ready for the Commonwealth to argue with respect to condition 13? The Commonwealth is requesting the first 12 conditions, and just for the record, I'm going to indicate what the conditions are. The conditions are: number 1, that the defendant not commit a federal, state, or local crime during his period of release. Number 2, that the defendant will remain in custody of a family member who agrees to assume the supervision and to report any violation of a release condition to the court and probation, and who is able and reasonably assure the court that the defendant appear as required and not pose a danger to the safety of any person or the community. Number 3, that the defendant will admit himself to the aforementioned facility within 24 hours of his release from custody and remain there until he is discharged. Number 4, that the defendant will sign a release authorizing that facility to notify a particular local police department, the Maynard Police Department, and the probation department if the defendant leaves the facility prior to discharge. Number 5, the defendant will abide by all follow-up conditions or recommended treatment, including medications that facility recommends. Number 6, that the defendant will sign a release authorizing that facility to notify the probation department of any recommended follow-up conditions or treatment in order to supervise the defendant in that care. Number 7, that the defendant agrees not to ingest any drugs or alcohol and subject himself to random screening by the probation department. Number 8, the defendant agrees to surrender all firearms, not possess a firearm, and not be in any residence or location where a firearm is present. Number 9, the defendant will stay away from the residences and places of work of both listed victims, as well as any witness listed in the police reports provided. Number 10, the defendant will not have any contact, either directly or indirectly, with either of the listed victims or any witness listed in the police reports provided. This includes calling third parties and asking the whereabouts of either victim. Number 11, the defendant will attend counseling sessions with a particular psychiatrist and will abide by all follow-up conditions or recommended treatment, including medications that psychiatrist recommends. Number 12, the defendant will sign a release authorizing that psychiatrist to notify the probation department of any recommended follow-up conditions or treatment in order to supervise the defendant in that care. Those are the 12 agreed to conditions, and the 13th condition is what I would wish to argue. I apologize, Your Honor. It's a psychologist, not a psychiatrist, for the record.
And that's a correct representation, Judge. We've agreed to those 12 conditions.
Your Honor, with respect to the 13th condition that the Commonwealth is looking for, the Commonwealth is asking the defendant wear a GPS bracelet 24 hours a day starting today. The Commonwealth would inform this court that it has consulted with the probation department and a GPS bracelet is available to be put on today, so it will not cause a delay. The Commonwealth is asking that the defendant have an exclusionary zone around the 2 listed victims' residences and places of work, that he only be allowed to leave his future residence for the following reasons. Number 1, treatment at that residential facility. Number 2, appointments with that doctor. Number 3, other medical appointments that are pre-authorized by probation. Number 4, appointments and meetings with his defense counsel that are pre-authorized by probation. And number 5, religious services that are pre-authorized by probation. The reason that the Commonwealth is asking for that condition, that additional condition, Your Honor, is twofold. The first is the facts of the case, and the second is the nature of the danger that this defendant potentially poses. With respect to the facts of the case, Your Honor, the facts of the case are that approximately 9 o'clock on June 12th of this year, 2012, the defendant's wife appeared at a friend's house, a friend that she had not actually seen in a long time. When she appeared at that house, she was crying, she was hysterical, she had a swollen lip, a severe limp, she was barefoot, she didn't have her keys, she didn't have her purse, and she didn't have her phone. She relayed to that person that she had just been assaulted by her husband. She relayed to that person that she had come home from work, the defendant had started yelling at her, he proceeded to severely assault her. He ended up taking her phone from her, that's the intimidation of a witness charge, and she fled the house without even being able to get her phone or her purse and fled to that friend's home. She told the friend about that assault. They then subsequently went to another location. After they went to another location, the victim in the case, the wife in this case, wanted to go back to her residence to be able to obtain her shoes and her purse. At that time, she went back to the house because she believed that the defendant would either not be there or not assault her further in front of someone else. She went back to that house to get those items, but the defendant was present. He immediately came after her. He grabbed her in a chokehold, swung her around, and slammed her into a kitchen counter. He began yelling at both victims. He told the victim that I'll kill you. If I had guns in the house, I'd kill your friend, and then I would kill myself. He lunged at the friend. The friend avoided him and fell down the stairs. The defendant then went back to the victim, to his wife, picked her up off the ground, threw her onto a bike rack that was hanging on the garage wall. Both victims then fled the apartment. The defendant actually went after him, but they were able to get into the vehicle and drove away. The following morning, the victim was seen by other individuals, and she was noted to have severe bruising on her back, arms, extensive bruising on her arms and legs. She had back pain, she had a swollen lip, and she was walking with a limp. She was treated at a hospital and released. That next day, the defendant continued to call the victim's cell phone. He demanded to know where she was. A friend of the victim, a different friend of the victim, picked up the phone and actually spoke to the defendant on the other end of the line. The defendant told that friend, if she doesn't talk to me, I'm going to come to her work and, quote, do some damage. The defendant subsequently did go to her work and was told to leave that work by a police officer. After all of this information came to light, the police department went to go arrest the defendant. They placed him under arrest, and the defendant repeatedly slammed his head against the cruiser after his arrest. After and during the investigation, the Commonwealth learned from a witness that the victim had told her that there had been some history of abuse, that during the course of their relationship, the defendant had used his firearm in the house. The officers subsequently also found out that the defendant, in addition to those statements that were made to the victim and the friend about killing them and killing himself, the defendant actually had made a noose in his residence to try to kill himself. The police officers observed the noose and photographed the noose. Because of those facts, the Commonwealth believes that this is a very serious case, that the facts are very serious, and that a bracelet is warranted. Because of those facts and because of the nature of the high-risk factors present of this defendant to both himself and other people, the Commonwealth believes that the bracelet would be a necessity in this case in terms of releasing the defendant. The factors that the court can consider in terms of holding a defendant under 58A are present, and the court can also consider them if the court were inclined in terms of whether or not a bracelet is needed for this defendant. One of them is obviously the nature and seriousness of danger posed if released. The next one is the nature and circumstances of the offense, as I just described. The next is the risk that the defendant would obstruct, threaten, or intimidate anyone, as I've just described. The next is the history of mental health of the defendant. Obviously, in this case, we do have threats to kill himself. We do have the noose that was made. We do have the fact that he was evaluated by a doctor at Emerson Hospital and found to be an immediate threat to himself. I will recognize that defense counsel will most likely argue, and I have previously told the court that after he went to Plymouth County, he was evaluated by a nurse practitioner, and at that time he was found not to be an immediate danger to himself. But the Commonwealth would suggest that the facts that were presented to the Emerson doctor were different than the facts that were presented to the doctor at the Plymouth House of Correction. For example, the defendant admitted to the doctor at Emerson Hospital about the noose and about all of that type of thing. The facts that were presented to the nurse at the Plymouth House of Correction were that he indicated that he had just been under the influence and may have made several comments when he was under the influence. The Commonwealth's position that he would be downplaying his mental health to that provider at the Plymouth House of Correction. And because of that, the Commonwealth believes that a bracelet is necessary in order to assure the safety of the two victims in this case, the public as well as the defendant himself. And that's why the Commonwealth is asking for the bracelet to be imposed in addition to all of the other conditions.